Hi friends, good evening. Welcome to Annamaya IAS Academy. This is Dr. Harinath Reddy, Director of the Institute. Today in this particular video, we will try to discuss about 130th Constitutional Amendment Bill in detail. So recently this Constitutional Amendment Bill was tabled in the Parliament. So this bill tries to amend several articles in the Indian Constitution, and it says that if any Prime Minister, Chief Minister or Minister is arrested and is in jail for 30 days in a case where the punishment is 5 years or more, then he can be removed from the office, either by the President. If it is a Union Minister, on the advice of the Prime Minister, the President can remove him. If it is a State Minister, on the advice of the Chief Minister, the Governor can remove. So if the President or the Governor cannot remove the Minister, then after the 30 days it becomes automatic removal. So that's what the amendment bill says. So 130th Constitutional Amendment Bill 2025, it says that in all the cases where the punishment is 5 years or more, if the Prime Minister or the Chief Minister or the Union Minister or the State Minister is arrested, if he is in the jail continuously for 30 days, then he can be removed from the office by the President or the Governor on the advice of the Prime Minister or the Chief Minister. And if they are not removed, then it becomes automatic after the 30th day. That's what the bill says. So here the bill says that merely arrest, it's not conviction, it's not awarding of punishment. Merely arrest can result in the removal of the minister from the office. So this is very much severely criticized by experts and also the political parties which are in opposition. And let us see the context. Why such a bill is necessary in the first place? Such a bill is necessary because there is a growing criminalization of politics in this country. For example, according to Association for Democratic Reforms, an NGO, and also National Election Watch, Association for Democratic Reforms and National Election Watch, they have come up with data. In 2009, in the Parliament, 30% of the legislators have a criminal record. In 2014, it is 34%. In 2019, 43% of the legislators, parliamentarians have a criminal record. In 2024, 46%. So this says that, this very clearly says that there is a growing criminalization of politics in this country. So those who break the law, if they become the lawmakers in this country, then that is a danger for Indian democracy. So this is the context in which this bill assumes importance. Then if you take what are the articles which will be amended. So the 130th Constitutional Amendment Bill says that Article 75, a new clause will be added, 75(5)(a). So 3 articles will be amended through this bill, through the 130th Constitutional Amendment Bill. 3 articles are amended, Article 75, Article 164, Article 239(a). And Article 21 says, in India, the principle of the criminal law is, unless proved, a person is presumed to be innocent. So merely on the basis of arrest, if the Chief Minister or the Prime Minister or the Minister is removed, then this is something which is against the principle of criminal justice system. What is this principle? This principle says, unless you are proved guilty, unless proved otherwise, you are not guilty. Unless it is proved in a court of law, till it is not proved in a court of law, you are innocent. So merely because of an arrest and staying in the jail for 30 days, if you ask the Prime Minister or the Chief Minister or the Minister to vacate the office, then this is something which presumes the guilt of the person. It presumes not innocence, it presumes that the person has done wrongdoing, which may not be true. Then Section 8, Clause 3 So we have an important legislation called Representation of Peoples Act 1951. Under this act, section 8 clause 3 says, if any member of the parliament or any member of the state legislature, if he is convicted in an offence where the punishment is 2 years or more, then he gets disqualified to continue as a member of the parliament or the member of the state legislature. But they had a protection. The protection is till 3 months, even if they are convicted, even if a member of parliament or a member of state legislature is convicted, given punishment where the punishment is 2 years or more, they don't need to be disqualified immediately. They will have 3 months time. They can go for an appeal before the High Court or the Supreme Court. If the High Court or the Supreme Court provides them relief, stays the conviction, stays the punishment, they can continue as the legislators. So here under the Representation of Peoples Act 1951, a legislator can be disqualified only after the punishment is given. So, but even this 3 months period was struck down as invalid by the Supreme Court in a famous case called Lilly Thomas versus Union of India. In Lilly Thomas versus Union of India, the Supreme Court said, when the legislator is convicted, given punishment, he gets immediately disqualified. The 3 months waiting period which is given to him to go and appeal, to the High Court or the Supreme Court on the decision of the lower court, this provision was declared invalid by the Supreme Court because Article 14 in the Indian Constitution says equality before law. So if the members of the parliament and the state legislatures are given 3 months period for not getting disqualified, this violates the principle of equality before law under Article 14 and the prohibition of discrimination under Article 15. So under the Representation of Peoples Act 1951, if a legislator gets convicted, gets punishment, he gets immediately disqualified. But here under the 130th Constitutional Amendment Bill, we are saying merely because of arrest, not because of getting punishment, merely because of arrest and merely because the person stays in the jail for more than 30 days, he has to be removed from the office. That's what the Constitutional Amendment Bill says. If you take some of the important cases like Arnesh Kumar versus State of Bihar, in this case, the Supreme Court said, if a person, the police had the power, legal power to arrest a person, but unless there is a strong justification, a person should not be arrested unnecessarily. Because if a person is arrested unnecessarily without justification, it results in the humiliation of the person, his freedom is curtailed, and there will be a permanent blot on him because of such arrest. So, in other words, the Supreme Court said a greater care must be taken before a person is arrested. Unless there is a strong justification, a person should not be arrested. Personal liberty is very valuable, and it is a serious thing if the personal liberty is deprived. That's what the Supreme Court said. It's not only that. In one more case, Joginder Kumar versus state of EP versus the state of Uttar Pradesh. Joginder Kumar versus state of Uttar Pradesh. Even in this case, the Supreme Court said, merely because the police had the power to arrest, merely on the basis of suspicion, police can arrest any person. So merely because the police had the legal power to arrest a person, this power should not be exercised. Unless there is a strong justification, it should not be done. Because if it is done, personal liberty, which is highly valued, will be lost by the person. That's what the Supreme Court said on arbitrary arrest. It's not only that. Arnab Ranjan Goswami versus Union of India. In this particular case, the Supreme Court said, if a person is arrested unnecessarily without justification, it amounts to harassment of the person. So the 130th Constitutional Amendment Bill can be misused against the chief ministers and ministers of the opposition political parties which are in power at different states. Because we have seen that Enforcement Directorate and the CBI, Enforcement Directorate and CBI, they have been misused by the government at the union level to arrest the opposition party ministers and the chief ministers in the states. So merely on the basis of arrest and being in the jail for 30 days, if that becomes the ground for the removal of chief minister or minister or from the office, then this is something which undermines democracy. This is something which is undermining federalism. That's what the political parties in the opposition were criticizing the 130th constitutional amendment bill. And there are certain important legislations called Prevention of Money Laundering Act, Unlawful Activities Prevention Act. So if a case is booked against a PMLA and Unlawful Activities Prevention Act, getting bail is very, very difficult. Though subsequently you may be proved innocent, but you have to suffer months and years of imprisonment. So that's why in India, process itself is a punishment. A person may get arrested, an innocent person may get arrested. Subsequently, after long years of imprisonment, he may be declared innocent, but he has already undergone that pain and trauma and that loss of reputation as well. So that's why this bill was severely criticized. It was also criticized that it will violate the theory of separation of powers. So the executive branch can get the person arrested through the police, but whether the person has done mistake or not, it has to be verified by the judicial branch. Without such verification, without the judiciary passing on the judgment of punishment, if a person is punished by saying that he should vacate the public office, then that is something against the principles laid down in the criminal justice system in this country. So that's why it was recommended that unless the Central Bureau of Investigation and ED were given sufficient autonomy, this bill will pose a danger. You know that many a times the Supreme Court said CBI is a caged parrot speaking the master's language. So Enforcement Directorate and the CBI today in this country are not truly autonomous and independent. So there is every chance of misuse of these institutions against the opposition political parties. So in this context, a constitutional expert by name Faizan Mustafa has argued that there is a compelling need to give autonomy, greater autonomy and independence to institutions like ED and CBI. And when Arvind Kejriwal was arrested in the liquor scam case, he did not resign. This is the background in which this constitutional amendment bill was brought. Even the Delhi High Court said the existing provisions in the law will not force a person like Arvind Kejriwal to resign to the office of the chief minister, because nothing is proved till then. So merely because he is arrested is not a sufficient ground for asking a person like Arvind Kejriwal to resign from the office of the chief minister. That's the view expressed by High Court, Delhi High Court. Then there was one more important case called the Jan Chowkidar case. So this Jan Chowkidar case said that this is again an attempt by the Supreme Court to fight criminalization of politics. If a person is arrested and if he is in the jail, he cannot exercise the right to vote. That's what the Representation of People's Act 1951 says. If you are not in a position to exercise your right to vote, then you are also not eligible to contest to the office of the parliament or the state legislature. So this case was filed by an NGO called Jan Chowkidar and the Bihar High Court. This is all happened in Bihar. So in Bihar, the Patna High Court said a person who is already in jail cannot vote and he is also not eligible to contest in the election. The matter went to the Supreme Court. The Supreme Court has upheld the decision given by the Patna High Court. But subsequently, the judgment of the Patna High Court and Supreme Court was undone by amending the Representation of People's Act 1951 in 2013. This amendment said, even if a person is in jail, as long as his name is in the electoral roll, he can contest in the election. Though he cannot vote, he can contest in the election. So in the Supreme Court and the High Courts were trying to deal with the criminalization of politics that is being undone by the Parliament through the amendments to the Representation of People's Act. So this is the context in which the 130th Constitutional Amendment Bill has to be seen. So which means merely on the basis of arrest, if a person is asked to step down as the Prime Minister or the Chief Minister or the Minister, this is wrong, because unless your guilt is proved, you are not criminal. So you are innocent. You are innocent as long as your guilt is not proved. So why should the innocent persons pay a price of losing the public office merely on the basis of arrest? And the bill is referred to the Joint Parliamentary Committee Once it goes to the joint parliamentary committee, there will be a lot of consultations. So different political parties can give their views, state governments can give their views, experts can give their views. On the basis of all this feedback coming from different sources, the 130th constitutional amendment bill may undergo changes, and once the bill becomes more acceptable, then only it will be taken up in the parliament. And some criticize that this bill is an attempt to divert attention of the people from the electoral revision issues in Bihar, where Election Commission of India is being targeted. And even if the bill is taken up in the parliament, this being a constitutional amendment bill, you need the support of 2/3 of the members present and voting, and also total strength of Lok Sabha and Rajya Sabha. More than 50% of the total strength of Lok Sabha and Rajya Sabha shall agree. In addition to that, 2/3 of the members present and voting on the day the bill is taken up shall also agree. So this is quite impossible to get in the given parliament, because BJP and its coalition political parties do not have 2/3 strength in the Lok Sabha or in the Rajya Sabha. So this bill is very difficult to get passed unless the government of today at the union level tries to build a consensus and takes into consideration the concerns of the political parties in opposition. So that's it about 130th constitutional amendment bill. Thank you and all the best.